because of the longstanding belief that it is harder to lie about somebody to their face than behind their back. Here, the lower court granted the state's complaining witness a Rule 807 accommodation, allowing her to testify outside the presence of the defendant, even though the testimony at the only relevant Rule 807 hearing utterly failed to meet the rigorous standards required by Rule 807.
Which testimony was that? I mean, there's three levels here. There was the first level where they said, we don't have anyone. Second level where they had the school counselor, and the third level where they had the counselor / yoga instructor. So which one, where are we on the where it failed?
We're on the third one, Your Honor. The first one was an initial statement, an indication by the state that they felt initially that they couldn't meet the standard. The second reference that Your Honor is making is to the first hearing, which was essentially replaced by the subsequent hearing, the 2023 hearing.
Was that
So,
Ms. Case?
I'm sorry.
Is that Ms. Case, Mr.
Yes,
Dunn?
Ms. Case, Faith Case is the only witness
Thank
whose
you.
testimony is relevant to this issue on appeal.
Apparently, the state doesn't agree with you, as their briefing goes into what happened with now it's framed by Justice Cohen, the second hearing.
Right.
There's
So
extensive discussion of that in their brief.
to be clear, the state does not actually make an argument as to why the testimony from the first hearing should matter, but they do confusingly combine the testimony from the two hearings. But I would just note that initially, at the bottom of the last paragraph in the second hearing, the hearing concerning Faith Case's testimony, the court states, based on the evidence presented at the hearing, and it's referring to the second hearing, the court makes the following findings and issues the following decision. So the ruling that is the subject of this appeal was based only on testimony that came from Faith Case at the second hearing. And therefore, we don't even have a court order on appeal that results from some sort of a combination of the two hearings. The court that issued the second hearing wasn't even the court that heard the testimony in the first hearing, so it wouldn't make sense for that reason. And just finally, it also wouldn't make sense in the light of the whole point of this statute. In Maryland v. Craig, the United States Supreme Court held that face-to-face confrontation may occasionally not occur in certain limited circumstances if a case-specific finding of necessity is made. And what that means in these cases is that we are looking at the potential impact of the process of testifying in the defendant's presence on an actual human being. And we're trying to figure out what that human being would feel and be able to do in the face of that confrontation.
So, Mr. Dunn?
Well, there's only three of us trying to ask a question. Go ahead, Bill.
I'll
Sorry, Justice Eaton, we'll go by seniority here.
All right. Assume we agree with you on your position on the 807 ruling and that it was error. Why isn't the error harmless in light of the testimony that was adduced that is not subject to the 807?
Thank you, Your Honor. A few responses, and I welcome the court's questions, but I have a couple quick rapid fire responses. First, if the constitutional error in this case is harmless, it is difficult to imagine a violation of Rule 807 that would not be harmless. This was a credibility contest. AG testified, she made allegations. Ms. Sylvester took the stand in her own defense and denied them. The proof was not overwhelming. There was no physical evidence corroborating the allegations. The complainant was unable to say whether the alleged contact took place over or under her clothing, and even her own father initially suspected that she had been coached. Not only did Ms. Sylvester not confess or make any incriminating statements, but she took the stand at trial and testified in her own defense. And I would just draw the court's attention to the analysis that the Sixth Circuit Court of Appeals took in United States versus Moses, which is cited in our opening brief in the harmless error section of that brief. We cited it with a parenthetical for the proposition that, look, if there's no other testimony, there's no other evidence of guilt. If this was if only eyewitness, then the error can't be harmless. But a close review of what the Sixth Circuit actually directly suggested that courts should do when evaluating harmlessness with exactly this type of error is the following. They said that the proper approach is to assume that the damaging potential of the cross-examination was fully realized, i.e., assume that the credibility of the witness who had received the accommodation was essentially completely damaged or destroyed, the credibility of that witness. And then they said, the next step is to examine the strength of the remaining evidence, i.e. the evidence other than that provided by the witness who received the accommodation. In Moses, the error was found not to be harmless, even though there was a confession that was admitted into evidence. The court felt that there were some issues with the reliability of that confession. Respectfully, in this case, if the same analysis is applied, there is literally no evidence of guilt other than the evidence provided by the witness who received the accommodation. And I don't see any possible way that a Rule 807 error in this case could possibly be harmless.
So Mr. Dunn, where is the 807 error? It could be that the testimony wasn't there establishing the standard that's required by Vermont law, or it was there and it wasn't included in the court's decision on allowing the 807 testimony. Do you understand this?
I actually don't. I don't understand. The
So-
first part I agree. First part was certainly an error. I mean, I can speak to that if Your Honor would like.
So if the prosecutor didn't ask the right questions or didn't get the right information out, that's where the error is.
The state failed to meet its burden to establish that those prongs of Rule 807C had been met. It was their burden. This is a limited exception to a fundamental enumerated constitutional right. The state had the opportunity to call any witness they wanted. The witness they called didn't meet the standard. But if Your Honor would like me to discuss.
No. I want to just get it clear where you think the standard had been met and it wasn't included in the court's decision, or the standard hadn't been met at all.
The standard was not met, and even looking at the face of the court's written order, it's clear that the standard wasn't met. So I guess what I'm saying is we're not challenging the court's factual findings. There are no, having reviewed the testimony of that hearing very, very carefully, there are no there was no testimony that would have saved this hearing accommodation that wasn't included in the court's order. The court accurately summarized the most relevant parts of Ms. Case's testimony, and it still wasn't enough. And if I could just read one very brief portion that I think
And then
really
you'll get
cuts.
to my question, right?
I'm sorry.
Then you'll get to my.
Then I, of course,
Thank you.
then I will get to your question.
Thank
Just
you.
very, very briefly, I apologize. The court wrote, if AG were to testify in the presence of defendant, she may not be forthcoming, as it would be a difficult situation for her. That is the court's most relevant factual finding regarding the third, I call it a prong, but the third required finding of Rule 807C. That clearly, the word may clearly falls short of more likely than not preponderance of the evidence. That's actually discussed in Berquist and Maryland v. Craig. And Your Honor, I would like to hear your question.
Thank you. So I'd like to ask you about the standard of review. I know you have asked for, or you argue that it should be a de novo review. The state has argued that more appropriately, it should be abuse of discretion. VRE 611 gives the court the province of deciding the order of testimony, how testimony should be taken. Is this 807 hearing more aligned to testimony and how it should be taken? So therefore, would 611 be more appropriate in abuse of a discretion standard as opposed to the de novo? I know you argue that you would survive both scrutiny, but what's your view on that?
With all due respect, absolutely not even close. Like the court's administrative responsibilities for determining the order of witness, who sits where, the administrative aspects of a trial are completely unrelated to what is, in fact, it may look on its surface like it's really a question of who's sitting where. It's actually an extremely important legal conclusion related to a fundamental enumerated constitutional right, because any error.
That's the Sixth Amendment right to confrontation.
Sixth Amendment right to confrontation. To be clear, even if this were, I mean, the lower court was making a legal conclusion. We think the argument is there should be de novo review just because it's a legal conclusion. If we were arguing with the lower court's factual findings, the standard would be clearly erroneous. But the legal conclusion the court reached, that's de novo. And that's even without accounting for the fact that this legal conclusion was in fact a legal conclusion that had direct implications on an enumerated constitutional right. Unless I'll just say this before I reserve the remainder of my time, which is that there was another error in this case. It was an error that the lower court in fact found based on post-trial filings, and it was an error related, the court found a Fifth Amendment violation because the prosecutor asked a number of questions regarding Ms. Sylvester's right to silence after she had explicitly invoked that right in October of 2017. The harm caused by that improper questioning should be cumulative and considered along with the harm of the 807 violation here, and the result should be a new trial. I'd like to reserve the remainder of my time unless the court has questions.
Why isn't that, what happened? Why isn't that cross-examination, fair cross-examination under this Jenkins case that the state cites in their brief?
I believe, Your Honor, what Jenkins said is that pre-arrest silence is fair game for questioning, but post-arrest, post-Miranda, post-invocation of the right to remain silent, that period of time is a period of time during which it is not proper to question a defendant regarding their silence, because we know that the defendant has been advised of their right to remain silent, and they could very well simply be exercising that right.
I think it also invokes, in my mind, even more critically, the Sixth Amendment right, the right to counsel under
Absolutely.
Doyle. So
Absolutely.
there are two constitutional issues here that are critical.
Absolutely. The state notes that it cannot find in the record a place where Ms. Sylvester was actually Mirandized. However, we know that in October of 2017, she explicitly told authorities that she was invoking her right to remain silent. Whether or not she had technically been arrested at that point, been Mirandized, she was aware of the right. That's why she was being silent, and therefore it was improper for the prosecutor to ask so many questions about it.
I'm a bit confused by one of your comments. Are you suggesting that if we agree with you on the 807 issue, that's not enough for a new trial?
No, I'm
It
not.
needs to be cumulative error. That's what it seems like you're saying.
Oh, no, I apologize. I'm glad you asked. Not at all. Independent errors, both requiring reversal. I'm simply saying that when we are considering harm, we should be looking at all of the harm in this trial, particularly when it was a credibility contest, but absolutely not. The 807 issue in particular absolutely demands a new trial on its own. Thank you, Your Honor.
All right, we'll hear from counsel for the appellee. Please, for the record, introduce yourself, identify your client, and then proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is asking the court to affirm appellant's conviction for committing lewd and lascivious conduct against a child against AG. As the appellant did this morning, I will also start off with the 807 issues. Both the Vermont Supreme Court, this court, and the United States Supreme Court have been clear that the Confrontation Clause does not provide an absolute right to face-to-face confrontation. Rather, the clause reflects a preference for face-to-face confrontation, and that preference yields when necessary to fulfill an important public policy interest.
Mr. Meenan, doesn't 807 require specific findings in order to get that accommodation?
Yes, it does. 807 specifically says that 807 specifically recognizes one such policy interest, and that is to protect certain sensitive witnesses that include child witnesses. So, for example, under the language of the rule, a child age 12 or under may testify by two-way closed-circuit television without seeing the defendant's image if the court finds by a preponderance of the evidence that requiring the witness to testify in court and hear the defendant will result in trauma to the witness caused by the presence and image of the defendant, which would substantially impair the ability of the witness to testify. This court has recognized that that rule preserves the other elements of confrontation, such as the requirement of an oath, cross-examination, and the ability to observe a witness's demeanor. As a result, in Cameron, for example, this court recognized that testimony taken pursuant to the rule is both reliable and subject to rigorous adversarial testing in a manner that is functionally equivalent to in-person testimony. Under the rule, a court's findings are sufficient where a court finds that there is a high likelihood that the witness would be traumatized and that the trauma would impair the witness's ability to testify. In this particular case, there was ample evidence to establish
Excuse me.
Yes,
Doesn't the rule require that it's the ability to testify be substantially impaired, not just impaired?
yes, you're correct, substantially impaired. And the evidence in this particular case was sufficient to enable the court to make those findings.
What evidence is the state suggesting the court relied on?
The evidence is, the state is suggesting that the court can rely on both the testimony of Ms. Cadmeri and the testimony of Ms. Case. I know there were some questions as to whether or not the evidence from the first hearing was still relevant, and the state's position is that it was absolutely still relevant.
That's not what the judge said, though.
Well, I don't recall the judge saying that it was not considering Cadmeri's testimony at all. I do recall in the second part, when there was after the passage of time, when there was a second hearing and the state presented the testimony of Ms. Case, the court did primarily rely on Ms. Case's testimony. However,
It relied totally on Ms. Case's testimony. At least as I read it, it says a hearing was held on June 12th, 2023. At the hearing, the state called Faith Case, a licensed clinical mental health worker familiar with AG. Based on the evidence presented at the hearing, the court makes the following finding.
yes, I don't read that same language as saying that everything that happened during the first hearing is no longer relevant and admissible for the purposes of making an 807 ruling. The
But it
way
was
that
a
I read,
different- It was a different judge at the first hearing, right?
yes, it was.
Okay, and a different standard was applied at the first hearing. The rule changed between the first hearing and the second hearing.
Yes, but I don't interpret that as saying that the information that Ms. Cadmeri had to provide in terms of the complainant's mental state and the effect of testimony was all of a sudden no longer relevant. There was no specific statement that said, we're disregarding Ms. Cadmeri's testimony. The court's prior ruling is overruled and replaced. However, even if that were the case and the only relevant testimony were Mrs. Case's opinions, the state's position is that evidence alone would be sufficient as well. What Ms. Case said was that AG was negatively affected by the appellant's offense, and that if she were to testify, she phrased it in alternatively, but one of two things could happen. She could potentially freeze up or go into flight fight mode. And she specifically said that if that were to happen, if either of those two things were to happen, then she didn't believe that AG's testimony would be, quote, fully forthcoming or perhaps even fully accurate, end quote. This court has upheld 807 accommodations in similar circumstances, such as in Berquist, where the language was shut down rather than freeze up, and McLaughlin, where again, the testimony was shut down rather than freeze up or fight or flight mode. It's important to recognize when evaluating the weight of Mrs. Case's testimony, and the state would assert also Ms. Cadmeri's testimony, what the standard of proof actually is. It's preponderance of the evidence. The state is not required to show that any complaining witness seeking 807 accommodations is definitively 100% and without a doubt going to freeze up. We have to show that it is more likely than not that they will experience trauma and that trauma could substantially impair their ability to communicate or testify. And it's the state's position.
It's not just testifying, it's testifying in front of the defendant.
Right, and seeing the defendant's image. That's
A lot
correct.
of people have stage fright. A lot of people are afraid to speak publicly.
I'm sorry, I missed
A lot of
that last
people
part.
are afraid to speak publicly. And so, I mean, couldn't it apply to anyone? If you have, don't you have to tie it to the defendant? Result of the defendant being present?
Well, it's the state's position that that did happen in this case. I mean, Ms. Case did not testify that AG has a real problem communicating in general, and that if she was forced to speak with anybody, she wouldn't be able to communicate. But what the court did find was that if, even in a therapeutic setting, AG is experiencing these visceral reactions and not being able to communicate in front of someone whose job it is to effectively assist her and had been assisting her for approximately a year, what does that say for what might happen if she's forced to recount these same experiences in the presence of the very individual who perpetrated against her? And that's why I think Ms. Case said that if she had to testify, and she experienced this traumatic response, her testimony might not be fully forthcoming or even fully accurate.
He and you have recited this as saying that it could happen.
That's
And
correct.
that's enough. But the rule says it would substantially impair, not could.
Well, but again, the burden of proof under 807 is a preponderance of the evidence, right? So we have to show that it's more likely or not that AG would have an impaired ability to communicate. We don't have to show even beyond a reasonable doubt or beyond all doubt that she would have an impaired ability to communicate. And that's why in the state's brief, we take pains to say that this doesn't revert the standard back to the pre-2023 standard, because the substantial risk standard that existed before 2023 was very different. Showing by a preponderance of evidence that there's a substantial risk that somebody's ability to communicate would be impaired is very different from showing by a preponderance of the evidence that someone's ability to communicate would be impaired like the rule presently requires.
So, Mr. Meenan, I do agree, and I understand that the preponderance of the evidence is a low bar. But it almost appears to me in this situation that the trial court was trying to bootstrap the testimony of, I think it's the first witness, Ms. Kamari, to supplement the testimony of Ms. Case, or even if that wasn't apparent, it seems that's your argument, that you might not find it's enough just with Ms. Case, but if you combine it, then it's enough to meet the standard.
Well, the state's position is that Ms. Case's testimony alone is sufficient to meet the standard. It's also the state's position that just because the passage of time caused the court to revisit whether or not its initial order based on Kadmiri's testimony was still valid, that doesn't mean that it was saying we're completely getting rid of and ignoring Ms. Kadmiri's testimony. The
You think that's
question
the law
really
of the
was,
case? Is that the law? Is your argument that's the law of the case? There was no order though issued that
I'm
time,
not
right?
necessarily making a law of the case
Okay.
argument. I think if we just take a step back and look at how things played out as a practical matter, the question was, the court previously ruled that this sensitive witness was entitled to some accommodations. We recognize that there's been some passage of time, and it might be a good idea to take a second look as to whether or not those accommodations are still valid.
Right, but there's a missing piece here, at least in my mind, which is that by you calling on Kadmiri's testimony, there is nothing in the record to say that any of the opinions that she gave 30 months previous was still valid. That snapshot in time when she's giving her opinion still has anything to do with how this child is doing 30 months later. Nobody asked that question. It's not in the record.
I might agree with Your Honor, except for the fact that nothing in Mrs. Case's testimony directly contradicted Mrs. Kadmiri's testimony. In fact, their opinions were largely synonymous, even though they used different language. For example, Ms. Kadmiri said that she observed AG go into freeze mode. Well, Ms. Case used the phrase freeze up or flight or fight. And then Ms. Kadmiri said that she was concerned that testifying in appellant's presence would cause trauma. And Ms. Case testified that AG would be negatively affected. So their words, their phrases might be somewhat different, but they weren't contradictory to one another. And so when you look at the practical exercise that the court was engaged in, I think what the court correctly concluded was that, in fact, nothing had really changed for AG, and that testifying in front of the appellant and seeing his image would still create trauma, as Ms. Kadmiri had testified during the first hearing, and that if she did experience a traumatic response, then her testimony might not be forthcoming or fully accurate, and therefore accommodations are still warranted in this particular case.
Anything you'd like to say about the time from the initial hearing where the state said they didn't have any evidence to the last hearing where Ms. Case testified, and the amount of time that went on to allow the child from 8 years old to 12 years, 300 some odd days?
Yeah, I mean, that's what the record establishes, is that at some point the state said, we've made an inquiry, we've tried to gather the information necessary to determine whether or not AG needs accommodations, and we don't have that information. I don't think that that necessarily bound the state or prohibited the state from seeking accommodations in the future should it acquire such information indicating that AG was in fact a sensitive witness that warranted the accommodations that 807 provides. It would be like a defendant stepping up and saying, no, we don't plan on filing any motions to suppress, and then discovering something after a deposition and filing a motion to suppress. Provided that the motion is still timely, there'd be no reason to preclude a defendant from doing that. There's no reason to preclude the state from moving for 807 accommodations when it discovers information that supports the request. I would like to address the issue of the standard of review briefly, because I know that that was a question that Justice Waples asked. It's the state's position that 611 is more than simply an administrative responsibility that the court wields, as the appellant asserted during oral argument. In fact, the rule specifically says that part of its purpose is to make sure that we are engaged in the effective ascertainment of the truth and to protect witnesses. Well, that's exactly what Rule 807 does. It protects witnesses. And the state also disagrees that a de novo standard of review is inappropriate just because 807 requires some legal analysis. All evidentiary rulings, including authentication, require some level of legal analysis, and those decisions are still reviewed for abuse of discretion. Thank you very much.
Okay, how much time does the appellant have, please?
Appellant has 2 minutes and 11 seconds remaining.
Counsel.
Thank you, Your Honor. If Rule 611 were sufficient to protect the witness in this case without violating Ms. Sylvester's Sixth Amendment right to confrontation, we wouldn't even need Rule 807 at all. The trial court would simply be allowed to order witnesses outside the presence of the defendant, and no one would care. But the fact of the matter is, Ms. Sylvester had a Sixth Amendment right to confront the witnesses against her, and Rule 807 is designed specifically and narrowly to allow a specific accommodation that protects a constitutional right. Beyond that, I have nothing to add to what I said earlier, unless the court
Can I
has.
ask you a question regarding the age of the child from the beginning of the case until the hearing occurred? And there's you made an argument, I believe, in your brief about that the beginning, she's more vulnerable than at the end. Can you explain that to me?
Your Honor, I don't think I explained that very well in my brief. And I believe what Your Honor may be referring to is the fact that when the trial ultimately took place, it was only 8 days before the complaining witness turned 13 years old. At 13 years old, she would not be eligible for an accommodation, no matter what the findings of the court. And it was essentially a gloss on our larger argument that I don't think I articulated very well, which is just a way of saying she was very close to the point in time when any finding, even of trauma, wouldn't prevent her or wouldn't allow her to testify outside the presence of the defendant.
She was still in the sphere, though, of 807.
She was,
Still-
8
still-
days.
Still, she had her 13th birthday.
Correct, correct.
So, Mr. Dunn, one of your closing remarks before your rebuttal was if this court, you're asking this court to find 2 independent grounds for reversal, the 807 issue and then the Fifth Amendment issue on the post-arrest statements. If this court agrees with you and finds that there is justified reversal based on the 807 issue, are you not seeking a mandate from this court regarding the Fifth Amendment issue? Should this be a retrial so that that line of questioning that the trial court engaged in regarding the post-arrest statements should not be admitted? Or what's your
Yeah,
mandate?
we-
Tell me your mandate.
We just want a new trial, Your Honor.
Okay, okay.
Thank you.
Okay, please call a conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this morning.